Hello, Tim Cummins again, and welcome to the video for week 2. So, extensive conversations this week, particularly around some of the issues that are being raised on contracts and relationships, with many people expressing the fact they're looking forward to more on those topics, particularly negotiation in week 3. So just picking up on a couple of the interesting areas that I noticed on the message boards and some of the conversations that are going on. One related to the traditional problem of what you do when you have disagreement over whether or not items are fee or free. In other words, if somebody is seeking to make changes, are they chargeable changes, or were they in fact assumed in the original scope? Alternatively, of course, it may be that people are trying to avoid the change management process completely, and there is simply a debate over whether or not something is within scope or not. Now, this is a problem that's been going on for many years in many different industries, but it's becoming worse because we're moving more and more towards a services-based economy where the scope or statement of work is often the only real tangible determinant of what it was exactly that has been committed. Unlike a product, you can't touch it, you can't feel it. And so this comes down to a combination of factors, one being the quality of requirements. And there are certainly suppliers who take advantage of poor quality definition of requirements and see that as an opportunity to charge extra when the customer subsequently realizes what they really need. On the counter side, of course, there are customers who try to use their power to exert demands for further value at no charge by leaving those scope or goals somewhat vague. So this is a battleground, and I suppose that the key lesson for everybody to learn is you do need to be very careful, particularly if you're the less powerful party, to ensure that you have clarity over requirements, that you have a well-defined and well-written scope or statement of work. And many organizations tend to leave the writing of scopes and statement of work to the engineers or the project teams who may have had very little training in the disciplines needed to ask the right questions and make sure that there is clarity, and equally that the way they've written things doesn't contain ambiguity. Final point on this, also look carefully at your change management provisions. Is it clear how changes are going to be negotiated? What does constitute a change? Make sure that there isn't a unilateral right by one party or the other to determine whether or not it is a chargeable change or constitutes a change. Many times you'll find change management clauses which perhaps give the customer that unilateral right to decide whether or not something is chargeable. And finally, think about whether there can be some sort of mediation process built into your contract. A wise third party, somebody with good industry knowledge, a good background and backup of experience, can be invaluable as that arbitrator in situations where there is otherwise fundamental disagreement over whether things are fee or free. That also leads us to the bigger question of the fairness of terms and conditions. And one of the questions during the week was around how do you overcome the challenge of, particularly it was raised with the public sector, unfair risk allocation, unfair or unbalanced terms and conditions. And again, this is a very frequent issue. It is certainly true in many public sector contracts, but to be honest, it's also true in many private sector contracts, again, where there's an imbalance of power between the parties. A lot of this comes down to the whole area of opportunism, and I recently wrote a blog on opportunism in the Commitment Matters blog, maybe something you would be interested in going looking at. Opportunism in contracting tends to occur in two places. One is at the front end, where the more powerful party does indeed often see an opportunity to impose onerous terms and conditions on their counterparty. Now, there's a growing amount of evidence that that really does damage the eventual results in many cases, particularly, again, in longer-term services arrangements, because the disadvantaged party will often seek revenge through unreasonable behaviours in return during the execution of the contract. But it also will often dramatically impact the counterparty's behaviours. So rather than being open and transparent and honest, they are, of course, seeking to protect their interests in a contract where they feel disadvantaged. There is also interesting evidence that says in many industries, particularly construction and engineering, suppliers see a poorly defined set of requirements as an opportunity, and in fact will bid low price to win on the basis that they know the eventual customer requirements are going to be significantly different from those that are stated in the original scope. So that, for them, is also opportunism in a situation where they can potentially make a lot more money in change management post-award. It's a fascinating area, but absolutely one that any commercial or contracts professional, or indeed anybody who wishes to flourish in this area, really does need to focus and ensure that there is clarity of understanding, that there are not those gaps or holes, and that they have effectively drafted things in a way that the counterparty can't ride a coach and horses through them. So get your work checked, get other opinions, make sure that other people have the same understanding as you intended by what you drafted. And equally, as I said before, make sure that your change provisions are well drafted, that they're balanced, and where necessary, consider the use excuse me, of a third-party arbitrator or mediator to resolve any disagreements you may have. So I hope you're enjoying week 3, and I'll sign off at this point and be back again in a week's time. Bye for now.